allow allow the partners the flexibility of organizing their internal structure. LLP itself will be liable for the full extent of its assets. Liability of the partners will be limited. Important definitions. Body corporate. Section 2, subsection 1, clause D of the Limited Liability Act of the it means a company has defined in clause 20, clause D of the of section 2 of the Indian of the Companies Act 2013 and includes a limited liability partnership registered under this act. A limited liability partnership incorporated outside India. A company incorporated outside India but does not include a corporation sole, a cooperative society registered under any law for the time being in force, and any other body corporate not being a company has defined as clause 20 of the of section 2 of the Indian of the Companies Act 2013 or a limited liability partnership has defined in this act, which the central government may by notification in the official gazette specify in this behalf. Business section 2 1 E. Business includes every trade, profession, service and occupation except any activity which the central government may by notification include. Designated partner section 2 1 I J. Designated partner means any partner designated has such percent pursuant to section 7. Entity section 2 1 K. Entity means any body corporate and includes for the purpose of section 18 46 47 48 49 50 52 and 53 a firm set up under the Indian Partnership Act 1932. Financial year section 2 1 L. Financial year in relation to a LLP means the period from the first day of April of a year to the 31st day of March of the following year. However, in this case of a LLP incorporated after the 30th day of September of a year, the financial year may end on the 31st on March of the year next following that year. If a LLP has been incorporated in 15 October 2019, then its financial year may be form of 15 अक्टूबर 2019 to 31 मार्च, अगले साल में 1 अप्रैल से 31 मार्च. The Income Tax Department has prescribed uniform financial year from 1st April to 31 March of the next year. In keeping with the income tax law, the financial year of LLP should always be from 1st April to 31 March each year. For an LLP, section 2(1)(m). It means a LLP formed, incorporated or registered outside India, which establishes a place of business within India. Limited liability partnership, section 2(1)(n). Limited liability partnership means a partnership formed and registered under this act. The limited liability partnership agreement, section 2(1)(o). It means any written agreement between the partners of the LLP or between the LLP and its partners which determines the mutual rights and duties of the partners and their rights and duties in relation to that LLP. Partner, section 2(1)(q). Partner in relation to a LLP means any person who becomes a partner in the LLP in accordance with the LLP agreement. A small limited liability partnership, section 2(1)(ta). It means a limited liability partnership, the contribution of which does not exceed 25 lakh rupees or such higher amount not exceeding 5 crore rupees as may be prescribed, and the turnover of which, as per the statement of accountants and solvency for the immediately preceding financial year, does not exceed 40 lakh rupees or such higher amount not exceeding 50 crore rupees as may be prescribed, or which meets such other requirements as may be prescribed and fulfills such terms and conditions as may be prescribed. Non-applicability of the Indian Partnership Act 1932 section 4. Save has otherwise provided the provision of the Indian Partnership Act 1932 shall not apply to ILLP. Partners, section 5. Any individual or body corporate may be a partner in a LLP. However, an individual shall not be capable of becoming a partner of a LLP if he has been found to be of unsound mind by a court of competent jurisdiction and the finding is in force. He is an undischarged insolvent, or he has applied to be adjudicated as an insolvent and his application is pending. Minimum number of partners, section 6. Every LLP shall have at least 2 partners. If at any time the number of partners of a LLP is reduced below 2 and LLP carries on business for more than 6 months while the number is so reduced, the person who is the only partner of the LLP during the time that it so carries on business after those 6 months and has the knowledge of the fact that it is carrying on business with him alone, shall be liable personally for the organization of the LLP incurred during that period. Designated partner, section 7. Every LLP shall have at least 2 designated partners who are individuals, and at least one of them shall be a resident in India. If in LLP all the partners are bodies corporate, or in which one or more partners are individuals and bodies corporate, at least two individuals who are partners of such LLP or nominees of such bodies. Corporate Sale Act has designated partners. Residence in India. For the purpose of this section, the term resident in India means a person who has stayed in India for a period of not less than 120 days during the financial year. There is an LLP by the name Indian Helicopters LLP having five partners, namely A. Non-resident, B. Not resident, Mr. C. Resident, Mr. D. Resident, and Mr. E. Resident. In this case, at least two should be named as designated partner, out of which none should be resident. Hence, if Mr. A and Mr. B are designated, then it will not serve the purpose. One of the designated partners should be there out of Mrs. C and Mrs. D and Mrs. E. Characteristics of LLP: body corporate, perpetual succession, separate legal entity, mutual agency, LLP agreement, artificial legal person, common seal, LLP, limited liability, management of business, minimum and maximum number of partners, business for profit only, investigation, compo- compromise or arrangement, conversion into LLP, e-filing of documents, foreign LLPs. LLP is a body corporate. Section 21D of the LLP Act 2008 provides that a LLP is a body corporate formed and incorporated in this act, and is a legal entity separate from that of its partners, shall have perpetual succession. Therefore, any change in the partners of a LLP shall not affect the existence, rights or liabilities of the LLP. Section 3 of the LLP Act provides that a LLP is a body corporate formed and incorporated under this Act, is a legal entity separate from that of its partners. Perpetual succession. The limited liability partnership can continue its existence irrespective of changes in partners. Death, insanity, retirement, or insolvency of partners has no impact on the existence of LLP. It is capable of entering into contracts and holding property in its own name. Separate legal entity. The LLP has a separate legal entity, is liable to the full extent of its assets, but liability of the partners is limited to their agreed contribution in the LLP. In other words, creditors of LLP shall be the creditors of LLP alone. Mutual agency. No partner is liable on account of the independent and unauthorized actions of other partners. Thus, individual partners are shielded from joint liability created by another partner's wrongful business decisions or misconduct. In other words, all partners will be the agent of the LLP alone. No one partner can bind the other partner by his acts. LLP agreement. Mutual rights and duties of the partners within a LLP are governed by LLP, an agreement between the partners. The LLP Act 2008 provides flexibility to partners to devise the agreement as per their choice. In the absence of any such agreement, the mutual rights and duties shall be governed by the provision of the LLP Act 2008. Artificial legal person. A LLP is an artificial legal person because it is created by a legal process and is clothed with all with all rights of an individual. It can do everything which any natural person can do, except of course that it can be sent to jail, cannot take an oath, cannot marry or get divorced, nor can it practice a learned professional like CA or medicine. A LLP is invisible, intangible, immoral. It can be dissolved by law alone, but not fictitious because it really exists, but not fictitious because it really exists. Common seal. A LLP. Common seal. A LLP. An artificial person can act through it partners and designated partners. LLP may have a common seal if it decides to have one. Section 14 clause C. Thus, it is not mandatory of a LLP to have a common seal. It shall remain under the custody of some responsible official and it shall be affixed in the presence of at least two designated partners of the LLP. Limited liability. Every partner of LLP is for the purpose of the business of LLP, the agent of the LLP, but not of other partners. The liability of the partners will be limited to their agreed contribution in the LLP. Such contribution may be of tangible or intangible nature or both. The professionals like engineering consultants